I'm humbled and honored to be the speaker in this memorial lecture today. Thank you very much for inviting me. I'm very sorry that that it was in such circumstances where I'm speaking to you from Tel Aviv instead of coming to Colombo. In recent months and weeks, I read about Sri Lanka, and I'm very passionate now on coming sometime to Sri Lanka. So hopefully that will happen sooner than later. I do believe, after reading a little about, or as much as I could, about Sri Lanka and about the crises that you're experiencing, that there is a lot to be learned by someone like me coming from Israel, from your experience in Sri Lanka. So thank you very much for inviting me to talk a little bit about my work and the insights that I have to share with the audience here. Cause lawyers are a special kind of creature. They're different than regular lawyers. It's not just our ego that tells us that we're something different. It is actually the type of clients that we have. Unlike, again, regular lawyer that has just one client and he or she has to do everything in their power and by the law to help the client to secure a remedy. A cause lawyer has at any certain moment at least two clients. One is the flesh and blood client, or the organization, or the party to the litigation which he or she represents, and the other is the cause. And I will not be talking today about the very interesting question of what happens when the interests of the client or the desire of the client collides with the cause. This is a dilemma that cause lawyers, including human rights lawyers, do encounter from time to time. I would like, though, to talk about a different dilemma, because human rights lawyers, as members in the family of cause lawyers, do encounter many kinds of dilemmas in their work. And the dilemma that I wanted to talk about is what I term as the human rights lawyer's existential dilemma. The question that human rights lawyers in many places in the world, in many eras in the present and in the past, and I'm sure that many lawyers will encounter this dilemma in the future as well, encounter when they operate in a legal environment of a regime that massively violates rights. And there is something especially different when a legal environment is one where the rule of law is used or exploited or actually abused to be used as a rule by law. The noble idea of the rule of law, which we all want to advance, where the idea that norms that apply equally to all, that were written together by all of us in the participation of all, apply equally to all of us. And that is a method. This is a tool which we believe may advance in the best way for each and every one of us a situation in which we could develop ourselves and our abilities to the best extent possible. But when the rule of law becomes rule by law, then the same bricks that we use in the world of law are being used and exploited and abused against this noble idea. And then the question arises, should we, as the workers of the law, should we participate in such a system? Should we litigate cases in a court that is the court of the abuser, the court of the legislator, of the executive that is abusing the law? And that is a question that I think many human rights lawyers in many eras have encountered time and again. And I think that lawyers that operate in Israel, human rights lawyers that represent Palestinians, individuals, communities, encounter that on a daily basis. I'm sure you all know that Israel for the last 54, almost 55 years has been occupying Palestinian lands where millions of Palestinians live, and they do not have political rights. Their political rights have been suspended for the duration of the occupation, but the occupation has been prolonged and prolonged, and policies and practices that Israel applies to the occupied Palestinian territories are perpetuating our domination, the Israeli domination over those lands, and prolong the time wave in which Palestinian individuals and Palestinian communities have no political rights, which means that for the last 55 years, this is, a person that was born 55 years ago in Palestine had not known one day of liberty in his life or her life, was not participating in any process that generates the norms that govern our lives. I have a friend in a village, in a Palestinian village named Bil'in. He was a client of mine, now he's a friend of mine. He's more or less the same age as mine. He has 2 kids, I have 2 kids. But our life is completely different. We live 25 minutes drive from each other, but he has no civil and political rights. If he wants to go abroad, he needs the permission of the military commander. If he wants to build a house, he needs a building permit from committees that he has and his community have no representation in. If he wants to call the police are not his brethren. They are Israelis. So completely different life for us and for them. And probably the most important, given this situation, the most important task of human rights lawyers in Israel of this era is to participate in the struggle to end this subjugation of millions of people, to end this abnormal reality in which people who were born Israelis have full citizenship rights, full political rights, but those who were born in the same geopolitical area, in the West Bank or in the Gaza Strip, enjoy no such rights. So when we talk about litigation in Israel-Palestine, we have already more than 5 decades of experience of such litigation. And I, for one, believe that this litigation is a very good laboratory to investigate what kind of things we can extract from this experience. What kind of pros and cons are there in going to the abuser's court? And in order to explain better what is this dilemma that I'm referring to, I would like to explain what is the record of the Israeli court when it comes to cases involving petitions by Palestinians and Palestinian communities and human rights organizations that are meant to secure Palestinian rights. But before I do that, I want to say one thing about the purposes of such litigations, because in order for us to calculate whether these litigations were worthwhile or not, one needs to first define what are the goals, what are the purposes of such litigations. Well, I would divide the purposes to several planes or several layers. There's the regular layer of remedy for the client, and that's the natural one. A client comes with he's potentially being faced with losing his land, or he wants to be reunited with his next of kin that lives abroad, or any other human rights issue. And the human rights lawyer's task is to litigate his case and secure a remedy for that client. The second layer of purposes is a policy change layer. Human rights lawyers, as any cause lawyers, are struggling, are litigating cases with the aim of changing practices and changing policies, not only in the specific individual case of the client at hand, but every person that will be in the same position. And so in the last 5 decades of litigation in Israel, on issues stemming from the occupation of Palestine, there were dozens of cases in which a full policy or a practice was challenged in court. The practice of torture using physical means of interrogations in security investigations. A challenge to the policy of settlements. I will refer to it in a moment. The idea that Israel is allowed, has the power to establish Jewish Israeli settlements in the occupied territories and allow Israelis to immigrate from Israel proper to the territories that it has occupied, creating a community of occupiers, of landlords within the millions of Palestinians who are, as I said before, rightless and weakened. So we have the remedy for the client, and we have the remedy. We have a litigation for policy or practice change. And then sometimes we also have a third layer, and that third layer is a very tricky one, and that is the layer of regime change. Now, I don't want to say that that lawyers, have, as you all know, lawyers are very humble and they don't have big egos, and they don't believe that through the litigation they'll change the world. Well, human rights lawyers and cause lawyers, I would put it that way, want to contribute to changing the world. And a regime change, for example, the idea that the occupation of the Palestinians must end. This is not a policy change. This is a regime change. To end the occupation is to end the regime, just like in apartheid South Africa. Ending the apartheid was an act of a regime change. And human rights lawyers, whenever they operate in an environment of mass abusing systems, they do not only desire to secure a remedy for their client or even to change a policy. They would like to believe and to feel that they contribute to a change of the regime, a change that will once and for all stop the systematic violation and abuse of rights of those who are in the minority, or those who are weak, or those who are stripped of their rights. So we have these three layers, and there is an interplay between them. The right for a remedy for the client, policy change, and regime change. And then there is a fourth layer, which I want to share with you because I think it's very important. I think it's really important in Sri Lanka. Because cause lawyers and human rights lawyers among them also operate as movement lawyers. They service movements for social change. Not all change stems from litigation or from the courts, as we all know. Movements, political movements, to secure rights of indigenous people, of minorities, of those, of women, of LGBT members, etc., etc. Those movements need lawyers to protect them, to protect their space of operations. And in the last few years, in the last decade, we have seen all around the world, and from what I understand also in Sri Lanka, but definitely in Israel, we've seen authoritarian regimes stepping up, curbing, choking civil society, providing all kinds of restrictions to political action. And it is the role of movement lawyers, and they are usually human rights lawyers, to safeguard the space for the movements to operate. And that means to protect those who are being detained in demonstrations, and to protect the leaders to defend the leaders of political movements in the face of all kinds of legal action taken against them, from defamation lawsuits to indictments, criminal indictment, etc. So there are at least four layers of purpose in which human rights lawyers operate in such systems. And so what is the existential dilemma? In Israel, we have a court or a justice system, a court system, a judiciary that is independent, and professional. Our judges are independent. They're not getting instructions from anyone how to adjudicate, and they are professional. They're all lawyers with a lot of experience, and they are chosen to the bench according to their record as professional jurists. However, the court in Israel, throughout the years, has been, in some very strange way, has become two institutions. When you look at the record of the Israeli Supreme Court, you'll find that when it comes to cases that deal with individual liberties, in individual human rights within the state of Israel, the Israeli court was a fairly effective institution in protecting individual rights. It is considered even an interventionist court, an activist court that was not afraid in some cases to challenge very powerful politicians. But when it comes, the same institution, the same judges exactly, the same benches, when they had to deal with questions arising from the occupied Palestinian territories and the operation of the Israeli institutions there, especially and mostly the Israeli military, then we found a completely different court, a court with a record of koshering almost every policy and every practice that the Israeli authorities have been applying to the occupied Palestinian territories. Both when it comes to policies and practices that were meant to perpetuate and strengthen the domination of Israel over those areas, to curb any resistance, violent or peaceful. I can give you a few examples. The Israeli court, in complete violation of of a clear prohibition in international law, allowed the deportation of Palestinian activists, militants, terrorists, and some of them political activists from the Palestinian territory, something that is completely prohibited with no exceptions in international humanitarian law. The Israeli court allowed administrative detentions to become a commonplace tool to be used on hundreds and thousands of Palestinians. At every moment, even now, there are hundreds of Palestinians sitting in Israeli jails with no indictment, not charged with anything, not knowing what they are suspected of, and not being able to defend themselves. In times of tension, the numbers rise to 4 digits. In times of peace that are peaceful, there is now about 300 Palestinians are in administrative detention. The tool that was supposed to be rare and exceptional became the standard. Punitive house demolitions. The Israeli court has allowed a practice of demolishing houses of suspected terrorists, which is clearly a collective punishment for the family, and is prohibited, again, with no exception, in clear words, in clear terms, both in international human rights law and international humanitarian law. And yet, the Israeli court allowed it. It allowed targeted killings, or what we call assassinations, of people suspected of terrorist activity, and allowed it, which is something really unbelievable. And it also allowed the use of potentially lethal force against protesters. Only recently in Gaza, where the army conceded that it uses potentially lethal force even against those who are not, who do not pose imminent threat to life of others. And the court allowed it. I will not go over the very long list because I don't have time, but you'll have to believe me. The court has allowed restrictions on freedom of information, on freedom of speech of Palestinians, on freedom of association of Palestinians. It allowed to curb the right to protest, and actually in practice, There is no right to demonstrate in the Palestinian territories today. And it allowed a severe restrictions on freedom of movement and more the right to life, right to family life, etc., and more. So why do we go to court? If this is the record of the Supreme Court, why do Palestinian petitioners still petition the Israeli court? Well, because while the court is one of the pillars, the Israeli court is one of the pillars of domination over the Palestinians, one of the three legs on which the Israeli occupation stands: the gun, the settlements, and the court, the law. There are still islands of remedy in this ocean of dismissal of petitions by Palestinians. And the type of islands that we can see from the last 50 years of litigation, I can divide it into several segments. There are the Israeli High Court of Justice was effective in introducing and securing procedural rights to those Palestinians who are facing abuse of their rights. So, for example, while the court has not revoked even one deportation order that was issued, and there were thousands of them in the 80s and 90s of the 20th century. While it has not revoked even one deportation order against any Palestinian, it has allowed those who are about to be deported to enjoy due process rights, and the right to counsel, the right to be heard, the right to receive information about the reasons why they are deported. Same thing about punitive house demolitions. The court was a complete failure in the litigation against punitive house demolition was a complete failure. But the court was effective in providing due process rights for those whose house was going to be demolished, to be heard, to receive information about why, to right to counsel, and some more. So in the field of procedural rights, there were some remedies given. There were some policies, very rare, but there were a few policies that were reversed by the court, that the court intervened in. Most famously, torture. The famous Israeli case of 1999, when the court has outlawed 5 techniques of physical interrogation in security investigations of Palestinians, was an important achievement, probably the most important achievement for the Israeli Palestinian human rights legal profession. There is still torture in Israel. This decision is not waterproof, but it has to be said that the vast majority of cases of use of physical force in interrogations has been eliminated, and that was a big success. Also, in a case about human shields, the Israeli Supreme Court has outlawed the use of human shields, taking a neighbor in order for him to knock on the door of someone who's suspected and want to be arrested, in order to make sure that if a fire would be shot from that house, the neighbor will be injured and not the soldiers. The court did reverse that policy and declared it illegal. There are a few cases where direct remedies were given to clients. I had the privilege of litigating several cases on the separation barrier cases where land was taken, was separated from owners, from Palestinian owners, in order to erect this security barrier that Israel has built on Palestinian land, separating about 9% of the West Bank from the Palestinian citizens. And while the court koshered the idea of erecting such a barrier on Palestinian land in order to make the access of Palestinian militants into Israel more difficult, it allowed it. At the same time, it did make changes in specific segments so that the proportionality of the damage to Palestinians would be better. And so I had several cases in which There are families whose land was taken from them and restored through legal action. That is really important. For those families, this is their livelihood. This is their how they earn their living. And then there's the most important thing, and that is what we term here in Israel as remedies secured under the shadow of the court, not in court rulings. I'm sure you all have this experience that members of marginalized communities, of political minorities, are nobodies, absolutely nobodies, until they lawyer up and become petitioners. Then suddenly they have weight. Suddenly they are someone to deal with, someone to make deals with. And the court was, and still is, a very good place to go in order to make deals, in order to make settlements. And the judges many times put pressure on the government lawyers to allow some kind of relief to the clients. I'll give you one example, which I think is quite staggering. Many Palestinians are not allowed to go abroad, go out of the country. They are banned from leaving the West Bank because of all kinds of reasons. And I'm talking about tens of thousands and maybe even hundreds of thousands of Palestinians who are not allowed to go out. One Israeli human rights organization has had a project of filing high court petitions on behalf of those Palestinians who did want to go and meet family or go on vacation or for professional reasons. And in 75% of the petitions they filed, the petition ended with the army backing off and allowing the petitioner to exit the country without a hearing even. So going to court is a way to amplify and to strengthen the position of the petitioner vis-a-vis the government. So the court has provided a path to remedy for individual cases, mainly help in mitigating violations, but very rarely it intervened in a way that ended up in a policy change. So this is the existential dilemma that I'm describing to you. Do the benefits of these rare remedies, these islands of remedies in the ocean of supporting the government by the court in litigation, do these benefits outweigh the costs of the losses? What are the costs of the losses in court? Because as I described to you, in most cases, Palestinians lose in the Israeli court, in the vast majority of cases. And when they lose, there are several costs to that. For one thing, a stamp of the court in many circles provides legitimacy to the act done or committed against the client. This legitimacy that is attributed to court-approved practices is probably the first most important cost of going to court in such a system. Secondly, when you go to court in such an environment, the mere agreement to litigate in the abuser's court and according to the abuser's justice provides legitimacy to the whole system of government. People around the world would say, well, if all these human rights organizations and all these human rights lawyers go to the court in that X country, they probably believe that this is a good court to go to. They probably believe that this court is independent and professional and will make sure that the force is not used arbitrarily. And that's another cost. When you go to the court of the abuser, you provide legitimacy to the whole system of government. And not only that, if you want to win, if you want to retain some chance of winning, you have to use some of the narrative of the abuser. I'll give you an example. I can't go to the Israeli court and not say that Israel is democracy. I cannot say that the Israeli society and the Israeli justice system is not, planted in the world of liberalism and that it has commitment to basic values of freedom and human dignity. I have to play the game. I have to be in the same discourse. I have to use the same jargon. And when I do that, I also present, again, externally, that this is a system where the victim of human rights abuse can get a lawyer, has his or her day in court, can voice their arguments, and be heard by a neutral arbitrator, the judge. So all of these are costs. And the aura of non-arbitrariness, of use of coercive force, is another one of these. And lastly, I want to say there are many other losses, but I'll just mention a few. And the last one I want to mention is the resources and energy that goes to the litigation potentially could have be used in a different route, in the streets for a demonstration, in advocacy, public advocacy, or political advocacy, or diplomatic advocacy. When we go to court, it has its costs in terms of resources and in terms of energy, of organizational energy. So all of these are costs. And so this is the dilemma. Should I go in order to get these small number of remedies for individuals to the court where all these costs I'm paying constantly? Or let me give you the same in a more Shakespearean wording. To litigate or not to litigate? This is the question. Whether it is nobler to suffer the slings and arrows of outrageous case law in exchange for crumbles of remedies secured, or to boycott the abuser's justice altogether and by its delegitimization contribute to ending it. This is the dilemma. To be or not to be for a lawyer, to go to court or not to go to court. And I would like to suggest to you that the arithmetic of the calculation of the downsides and the upsides, the remedies secured versus the costs paid, is not as simple as it looks. Because in first inspection, we can look at all the victories and look at all the defeats that we had in court. It's very simple to identify victory and defeat. Victory is when the remedy sought was secured. It is a very simple event, and it deals with securing either the remedy for the client or the policy change, depending on the type of remedy that we sought in the specific litigation. And defeat is the opposite, when we did not manage to secure that remedy. But victories and defeats are not all the products of litigation. And I would like to suggest to you that in addition to victories and defeat, litigations yield successes and failures. And success is not the same as victory, and failure is not the same as defeat. Success places litigation in a historical context and measures its ability to contribute to changing the discourse, educating, inspiring a movement for change, and creating solidarity with disempowered communities. It is not always evident and calculable in the present. Sometimes it takes years before we can answer the question, so how that litigation contributed or failed to contribute to the changing discourse. to solidarity with marginalized communities? How did it have contributed or failed to contribute to the authoring of the indictment against the status quo? Because what are we all doing every day when we're in court? We are writing constantly an indictment against the reality that is at present. And we're not doing only that, we're also suggesting an alternative that should come in its stead. And so the question of whether this litigation was successful in promoting these kind of more social processes, this is what success is all about. And the opposite, failure. Failure is when a litigation creates a process or a trend that counters these things that we want to get to: the change of discourse, the elevation and empowerment of the movement for change and of those communities that we want to stand in solidarity with. So the difference between victory and success in social change litigation is that the first is an immediate event, obtaining the remedy sought through litigation. And that is the legal victory. The second is long-term. It is measured by the extent to which litigation advances social change by shaping the public discourse, by educating, building moral manifesto, which we all do all the time, and galvanizing the movement. And so when you ask yourself, was this litigation successful? When you ask if that litigation was victorious, the answer is very simple. But when you ask yourself, was it successful? Then the answer is much more complex. And I want to say that there are several byproducts to almost every litigation. And these byproducts are the engines, the wheels on which success or failure advance. And again, those cause lawyers are familiar with these byproducts. When we litigate, we secure information which we would not have secured in any other way, because only in court, usually only in court, the government is obliged to provide information that in other places it doesn't have to. And only in court that information has to be true. In other places, the government may lie, and sometimes with no repercussions. In court, the court proceedings almost always contribute to public awareness. There is something about litigation, about the nature of litigation, that makes it an extremely attractive, makes it extremely attractive to the media and to the public interest. The court is also the only place where we can corner a government to present a position. Sometimes the problem is not that the government is against or that it is in favor of something. Sometimes the problem is the government wouldn't say. And in court, it has to provide a position and account for it. And that is another very important byproduct of litigation, which sometimes is the whole difference between, the case might be a defeat, but it was a success in these terms. Litigation provides us with time, a lot of time, because sometimes years, litigation take years, and during those years, we have secured an injunction. And so all these years are years saved during which the violation that we are fighting against is not applied. And by the way, this is not just time saved because we postponed the violation. This is time that we can use to have advocacy. We have cases in Israel of attempts to forcibly transfer whole communities of Palestinians from remote desert areas. And thanks to the litigations that were all a defeat. After 11 years, one case, that's the case of Khan el-Ahmar, maybe you heard of it because it's quite in the news. and the other Susia, 17 years of litigation, all losses. But during those years, the activists, the politicians have been advocating against the removal of those communities. And even though today the court does not stand in as a barrier to the transfer is not, the forcible transfer is not carried out, because during the time that this community had, together with their comrades in the human rights organizations, they have managed to create a firewall through advocacy. So time is an important factor in success. And then you have what I said before, the authoring of the indictment. This is very important. We are people of words, lawyers, and we constantly articulate what is wrong about what is now happening. This is extremely, extremely important. This is what we do. And these words matter. They matter to the movement for change. The way that we articulate what is wrong, what is immoral, what is illegal in the current situation are words that are taken by the movement and are used, and in some cases they even inspire. So when we talk about litigation in very difficult environments, we should look at these not small, but these byproducts, and think of whether the case was not only victorious or whether we lost, but also was it successful. I mentioned the policy of deportations. Israel has been deporting Palestinians, those who were every time there was a new leadership, they were deported from the occupied Palestinian lands. And as I said before, hundreds of cases, hundreds of petitions filed challenging these deportations, not a single one in which the court has revoked the deportation order. But throughout the years, through these litigations, through the securing of due process rights, those deportations became from very easygoing incidents in which all you needed as the army was a jeep and a soldier with a gun, and you go to the house of those who you want to deport, take him on the jeep and pass him through the border. Throughout the years, through litigation, it became a monstrous procedure in which you had to have a hearing, and the person deported had to have a legal counsel, and they had the right to ask questions, the military commander to examine the military commander's position and file a high court hearing, a petition. And so suddenly it became a long process during which advocacy always began. A broad diplomatic advocacy, the media was reporting, and suddenly deportations were costly to the government. The image of the government was fractured. And in 1992, the last deportation took place. It was a big deportation of 400 Hamas and Jihad activists to Lebanon. And that was the last deportation ever since. The Israeli Supreme Court has not outlawed deportations, but through litigation, through these small byproducts that they galvanized the procedure into a lengthy and costly procedure in political terms, in political currency. And so it has been disused completely. So while there were defeats, the overall struggle was a success. It was a success story. So we can see that sometimes victories in our minds, and it's very natural, lead to success. They don't have to. Sometimes there is a backlash to the success. One such example is a success internally in Israel, when Israeli petitioners have managed to convince the court, Palestinian petitioners have managed to convince the court to declare illegal a policy in which housing units in small communities in southern and northern Israel were rented only to Jews. And the court has made this illegal. And there was a huge backlash in the form of legislation that allowed small community to discriminate. And this happened a few years after the case that I've described. And that new legislation, which is still on our books, and the court has not declared it unconstitutional. So sometimes victories may cause a backlash, and overall it will not be a success. And sometimes defeats would lead eventually to success. And so when we look at our work as lawyers who litigate cases, we have to see the complexity of this arithmetic or this calculation. And I get to the end of my remarks, and I want to close up by thinking with you together. So what does it mean? Are there really cases where this existential dilemma will end up with us deciding that it is better not to litigate at all? Now here's the problem. The problem is that if we are all holding a belief in humanistic values, if for us the individual, the human being, is the sacred thing, then whenever a system can still allow some remedy, and as a lawyer, we get a request from a client to represent them because they are facing a violation of their rights, they are facing abuse, can we tell ourselves, would that be the human rights answer, that we would not litigate that case, even if there is a slight chance of remedy, because there is a cost to going to that system? Can we say that to us? Humanistic approach, that is my belief, cannot allow sacrificing an individual for some greater, usually speculative good. And that, if you agree with me on that, that means that the question will never be whether to go to court, but how to go to court and when to go to court. Based as it is on moral and ethical values, the legal fight preserves an alternative to the abusive policies, even when no one seems to be interested in that alternative. It is not only lawyers who do the work of preservation of these alternatives. However, the critical, cautionary, educating voice of legal activists has a special role and importance. Constantly, we are defining and articulating the evil to be uprooted and the good that should come in its stead. And that is why human rights lawyers will never, that's my belief, will never ask themselves whether to fight for victims of abuse. Shutting their mouths, shelving their legal books, burying their pens deep in their pockets, this is not an option. No matter what the context, the abuse, the legal arena, because they cannot stay silent in the face of evil, because passivity is moral complicity, because their particular role in the struggle, wording its manifesto, is crucial. Although we, human rights lawyers, may sometimes ask ourselves how best to use our legal skills, we will not ever question whether there is a place for the law in the fight. For human rights lawyers, enlisting the law to combat oppression is not a choice. It is an existential act. Thank you.